seized of it?
I have him. He's here.
The chair, let's be a bit prudent with public money. Why this money was advanced in 2016, okay? 2015. Why does it take 10 years before the county attorney issues a demand letter for the recovery of this money? Yet he knows the statute of limitation may not allow him to recover that debt now. Is that negligence on his part? Huh? Because I'm looking at Annexure 3C, Chairman. The demand for the repayment of this money was made on 5th of June, 2025. Why that long inordinate delay?
Chair, I really wanted evidence, as alluded by the HR officer, that the officers indicated that they want evidence that that money was advanced to them. How would you know money is advanced to you? It's because either there is a wire from the county coffers to your account, or you have signed. So for the documentation, maybe the documents might not be there, but if there was a wire from the county CRF account to that officer, and that officer expended that money, then why should you want evidence whether that money was advanced to them or not? It should be very clear, because that money went to that person's account. Chair.
Governor?
Chair, I think my position is that is the Director of Human Resources that keeps all these records and should be able to avail them. But this is the explanation he gave, that he couldn't get the documentation because of that fire incidents which led to the burning of the documents.
But then what would be the basis of your demand letters? Letter of demand before action and recovery? I don't know whether it's the one you're referring to that were done sometime in...
Yes, and we want to understand from the county attorney whether he understands the Limitation of Actions Act in terms of debt recovery.
Chair, let me confirm that I understand the Limitations of Actions Act and the limitations.
What is the period? So that we test whether you are supposed to occupy that office?
Yeah, if it's on contract, then we are talking of 6 years. If it's related to land, it's 12 years. If it's related to tort, it's 3 years.
So what was this one? What was it relating to?
Chair, this is public money, and we received instructions from the Treasury. If you see, if you look at Annexure 3B.
No, was it within or it was already time barred? You're a lawyer.
Chair, we had to act. This is public funds.
You are sure you can file a suit?
Because you know the debt had not been written off. It was still a liability that was pending.
Are you a member of Law Society?
I'm a member, and I'm a very senior member. I was admitted in 1987.
Fine, so educators,
no.
Because...
the limitation.
Tell us on the limitation.
1980 Actions Act.
Governor, you may be very unfortunate if that is your county attorney who cannot understand basics on the time you need to file suit before you are time barred by the court.
Chair, that is very unfair, with the due respect, because I have not filed any suit.
County attorney, relax. Relax. Yeah? There's no need to raise your temperature. There are documents here which you have authored on the 5th of June. And perhaps it looks like you're doing the right thing, because I would have told the governor to advise you to do exactly what you have done. But senior counsel is raising a flag that due to the statute of limitation, this might be a futile exercise. That is what we need to deal with. I don't care when someone was admitted or what. Is this a useful exercise or it is a futile exercise? Let's establish that as a matter of fact, not as a matter of opinion. It looks like the right thing to do.
Chair,
But is it going to yield the results that we need?
Chair, we just issued
order through the chair. Wait, before it comes on board. I've read the letter that